Hi everybody, and welcome to another episode of North Alabama Law Review presented by Johnston, Weston. I'm your host, Shauna Hill, and today we have joining us Bennett Driggers and Mr. Mickey Gentle. Hey guys.
Hello.
Hello.
So I want to start this episode a little bit different today. Mickey, why don't you tell us a little bit about you, give our viewers some insight about who you are just as a person and as an attorney, and just things that you have learned along the way in your journey as being an attorney.
My name is Mickey Gentle. I'm a third-generation native of Madison County. Both of my grandfathers were from Madison County and grew up in this area. And I have lived here most of my life. I spent a little bit of time out when my father's job transferred him elsewhere, and I spent 3 years away when I was in law school. But other than that, I've lived in Madison County all of my life. I am married actually to another attorney, and so we are able to talk shop with each other and understand what we're talking about, which is pretty cool there. But we've been married almost 23 years. And I serve at the Harvest Baptist Church in Harvest, Alabama, as a deacon and on several committees, and I sing in the choir. But as an attorney, I started off doing just about anything that would come in the door. As my wife sometimes describes it as grocery law, whatever will buy the groceries. And so I started off doing that, and over the years I have gravitated towards doing family law and probate law and appellate work. And I've been on this particular show talking about various issues on all three of those areas. But that's what I have gravitated to. That's mainly what I do at Johnston, Weston. I do the divorce, custody, child support, visitation issues. I write wills, powers of attorney, advance directives, and I probate estates when somebody passes away. So, a lot of my running jokes say that I distribute assets. Sometimes it's at someone's death, sometimes it's at their divorce, but I'm distributing their assets. So, but that's a little synopsis of me.
Well, let me ask you this, Mickey. What made you decide to get into law?
Well, funny thing is I actually had pondered studying music and being a high school band director. But I took a class when I was in high school. It was called a Seminar for Law and Justice. And that was a one-semester long course, and then the next semester was a business law class. And I took both of those, and that developed an interest in the study of law for me. The next year, I had that same teacher for the government class that's required in the senior year of high school there. And I had that same teacher. And I talked to her a little bit about being a lawyer. And she gave me a few pointers on that. But because had she not been a high school teacher herself, she would have gone to law school, is what she told me. So she was thrilled that her student was interested in that. Yeah. So that's really where the interest started developing there, and then through going to college at UAH and taking political science courses towards a minor, that just kind of bolstered it even further, and then I ended up going to law school.
So what about your music? You said you loved music. You thought about doing that. Are you doing anything with your music now?
Let them know what instrument you played.
Yeah. Well, in middle school, I played trumpet, and I played the baritone horn in high school. Now, more than anything, I sing. I sing in the choir at church.
Oh, are you going to give us a demo right now?
Well, yeah. Mind you, I sing in ensembles. So if y'all want to join me in a...
That's quite all right.
I think people prefer...
We didn't warm up properly.
Yeah.
What do you like to do for hobbies? You have any hobbies?
Generally, the biggest thing that I do, my wife and I like to go to ball games. We actually were able to go this month down to Tuscaloosa and watch the regionals for the softball team, and then the super regionals the next week, and we'll go see Trash Pandas baseball. And that's what we like to do together. And that's really about all I got time for.
I love watching your guys' photos and all the new restaurants that you try. I'm always picking your brain.
Well, I do have one last. I'm sorry, Sean. I didn't mean to talk over you. I do have one last question. Aren't you in seminary now?
I am. I've got about 10 classes left, and I'll have a Master of Divinity in Christian Philosophy.
Awesome.
That's very awesome.
Sounds like you're pretty busy.
I am.
Well, good.
And definitely the kind heart and touch that people need for the area of law that you deal with. I think that's why you're so great and successful in that area. People, especially in a time of dealing with hardships like, family law and probate, have someone who can have a soft approach is definitely a good touch to have. We appreciate you.
Thank you.
Well, speaking of your areas of law, we're going to dive into today's topic. So today we're going to talk about guardianship and conservatorships. Unfortunately, a lot of people deal with this, but we don't necessarily know we're going to deal with it until the time comes to actually have to deal with it. So that's when our parents, when we see them take a turn, when they're having health problems, when our parents or even grandparents are having dementia, just any kind of way that they can't actively care for themselves and the correct action to take to allow you to care for them. So Ben, I'm going to let you dive on this one.
Sure. Guardianships and conservatorships are unfortunate that we have to have them sometimes, but they're a tool that you can use, again, like Shauna was saying, that if you have a parent that may be suffering from any kind of illness that are unable to do things for themselves anymore. There's other circumstances, like you may have an adult child that has been handicapped for some reason their whole life. And so there's other reasons to have them, but let me touch a little bit on it. The guardianship is basically it allows the guardian to take care of the personal affairs of, to make personal health care and living arrangements decisions on behalf of that individual if they can't make them for themselves. Guardianship is not to be confused with, I can handle their money. That's not what that's all about. That's where the conservatorship comes in. And in order to get a guardianship and a conservatorship, a petition has to be filed with the probate court, and the person will have to be deemed incompetent by a medical provider of some sort. And that can be mental incompetence or that their health and stability. In other words, they may not be able to get around on their own or drive on their own. It does not allow them to handle their own affairs, so somebody needs to be able to do that for them. So essentially, when you file a guardianship or conservatorship, the probate court will appoint what's called a guardian ad litem, which is a licensed attorney in the state of Alabama, to look out for the best interest of that individual. They're kind of there to make sure that what is best for that person is what ends up happening with the court. If that guardian ad litem feels after all their investigation into the matter that this is not what's best for the individual, that this individual may not be incompetent or may be able to handle their own affairs, they can express that to the court in a hearing on the matter, and then the judge will decide at that point. Some cases require both a guardianship and a conservatorship. Others do not. So it's going to depend on the individual situations in these matters on what is needed. And then there's the side of this where who is going to do this guardianship or conservatorship. You know, we'll touch on that a little bit more, but Mickey, do you have anything to add on that?
Well, you touched on a good bit there. Now, I have served a lot as a guardian ad litem in cases like this, and ultimately, the job is to do an investigation, look at the petition, understand what's being said in the petition, and at least go see the person that they're trying to get the guardianship and or conservatorship over. Because that probate judge a lot of times has asked me certain questions that only I could answer as the guardian ad litem. So, and I need to be able to tell that judge, Your Honor, I think this or that is in the best interest of this person, or that it's not, and let that judge know how I feel. And ultimately, as Bennett alluded to, it is up to the judge to decide that the petition will be granted or denied, but the guardian ad litem is a key element and essential to carrying out that case in determining what ultimately is or is not in that person's best interest.
Yeah, that's a very important aspect of it, and understand that there normally is a hearing on the matter, and the judge can take and does take testimony. Then on the flip side of that, you want to make sure that whoever's filed that petition is qualified to be that individual. Unfortunately, we live in a society where there's a lot of elder abuse and a lot of scams going on out there, and people taking advantage of the elderly monetarily. You'll have caregivers that will draw close to the individual and try to influence them in different ways, take advantage of their financial situation. All kinds of things are happening out there. So this person, they need to be vetted and qualified, and the attorney in the matter that filed that petition represents that petitioner, but the courts will question that individual. They'll require some testimony in that matter to answer some of the questions or concerns they may have about that individual, and then a decision will be made, like Mickey said, once everybody's had a right to give testimony and state their side of the case and their feelings on the case. So that's kind of in a nutshell. You're asking the court to do something that can seriously affect somebody's rights, their independence. As we grow older, that's one thing that we don't want to give up, is our independence as an adult. But if we're incapable of caring for ourselves and doing the right thing for ourselves, unfortunately, sometimes that has to happen. And that's what this whole guardianship and conservatorship side of the law is about, is ensuring that, one, there is somebody when a parent or a loved one gets in that position that can step in and help care for them, that won't take advantage of them.
That's very good point. So we talked about who would need it and how to go about getting it, but let's talk about once the judge actually grants the conservatorship or the guardianship. So once it is ordered or granted, what are the responsibilities of the person that is issued to?
You want to start, or you want me?
Yeah. The conservatorship part of it is really all about the money. When I've advised clients about getting a conservatorship, a guardianship, or both, I've suggested that the conservatorship is about the money. It gives that conservator the power to look after that person's money. The way it was always taught to me is, if you have a guardianship or a conservatorship, you are essentially stepping into that person's shoes, and you are conducting affairs in a way that person would do, or at least as close to that as possible. And so as the conservator, you are handling that person's money, and you have what's called a fiduciary duty, which it's more to it than, say, if somebody handed me a dollar bill to hold on to for a little bit. Certainly I want to take care not to lose that money, but a fiduciary duty has not been established. If I'm handling somebody's money as a conservator, I have a bigger duty to make sure that I don't do anything that could make that money go away and lose that money. I'm not authorized to take that money to Tunica and blow it over there, in other words. So that's how it boils down to with the conservatorship. With the guardianship there's a lot more of transacting business on behalf of that ward. And so, again, there's a fiduciary duty there. It's a little bit deeper than, say, if I were having to call somebody on behalf of my daughter and talk a little bit of business, as opposed to actually transacting her whole set of business affairs. And so I have to take care, if I am the guardian over somebody, to transact that business in a way that is acting in their best interest. So.
Yeah, it's important to realize that one, there's two sides of it. It's not only making sure you don't go spend their money in Tunica, but it's also a higher responsibility to care for and to not waste the estate, so to speak. In other words, don't go spend erratically or do things that, are going to waste the assets of the state that are unnecessary. So that's part of your fiduciary duties, is to make sure that even in terms of possibly investing some of that money, not at the poker table in Tunica, Mickey, but on behalf of the ward is doing investments to make sure their money lasts and you're able to take care of them through that.
So let's talk about the protecting vulnerable adults. So as you mentioned, it is a growing concern about elder abuse, not only physically, but financially as well. So what are some precautions that someone can take if they see it happening, such as someone spending grandma's money at the casino in Tunica?
Okay. Well, a few years back, now I'm aging, so I don't remember the exact number of years, Alabama finally passed legislation for protection from abuse for the elderly. And it was mainly put in place for those instances where someone feels an elderly person is being taken advantage of financially or unduly influenced to give their property to somebody, whatever the case may be. So that's one of the first steps is you can go down to the courthouse if you have the feeling that that's happening. You don't need an attorney for it. You can go to the courthouse and file a protection from abuse. You may want to consult with an attorney before you do that to make sure it's within that you have the evidence or the allegations are enough to do that. But at the same time, if there's a concern, don't hesitate. Take action to protect these elderly. They've given a lot for us, for the generations behind them, and so we want to be able to give back and protect them as they age. One of the other protections we can put in place is to plan ahead of time. There's things you can do that they can do as an individual to protect themselves ahead of time. Part of that process would be having power of attorneys in place, health care power of attorneys, durable power of attorneys, doing your estate planning. We do see estate planning issues, and we'll probably get into that in another show, but on this one, it's preparing ahead of time so that, look, when you have to take an elderly person in front of the probate court to try to prove them incompetent, it's pretty devastating to them. Even if they are having some incompetency issues, it's hurtful. They feel like they're being betrayed by their loved ones. All these other emotions come into play. Avoid all that. Go ahead and talk to your parents, your grandparents about having some plans in place for what's going to happen if you get sick or something like that. Who's going to be able to handle your affairs? Make those decisions known, and then go see an attorney that can put that in writing for you. Don't wait till all of a sudden they've been diagnosed with Alzheimer's and unfortunately, don't remember a lot, can't make decisions on their own. Do it before that point. It's important to make sure that you take them there when they're competent and they can make those decisions on their own. And you're going to avoid all this conservatorship, guardianship process through the probate court. It's not any fun. It can get expensive. And again, you're taking this elderly person's independence away. And we're talking about the elderly here, but this, like I said earlier, this can also mean a handicapped adult child that needs care. So make arrangements ahead of time. Make decisions now before it gets to a point where you've got to do this very intrusive action on these folks' lives, and have the documents, appropriate documents, drawn up by an attorney to make sure that you're ready for that and that they're prepared, and then they're a part of that planning. They trust that plan more, and they can pick the individual that they trust to do those things for them, instead of the court deciding, okay, this person not qualified, we're going to put somebody else over this estate or this person. So keep those things in mind.
I think a key point you mentioned is really doing it early on, especially if you're dealing with older people and their competency. I'm sure all of us at one point has dealt with a family member with dementia. It's not fun when they get to that stage and can't remember what's safe for them or what's best for them. So definitely have that in place when they're competent. It can save a whole bunch of trouble for sure.
Well,
not necessarily easier, because they're still going to fight you.
They're independent. They're mom or dad or grandpa. Yeah.
They're still going to fight you.
Well, I think I missed one important group here. Anybody else that's an adult should have these plans in place. You never know when there might be an auto accident or some traumatic health issue that can take away your independence, even at young ages. So it's good to have these plans in place. Just because you have a spouse doesn't mean they're going to be allowed to take care of some of your affairs. It depends on how you have bank accounts and mortgages and all this other stuff set up. So it's all a part of being prepared for these things that are unexpected but do happen in people's lives. So like Shauna said, don't wait. Now's the time, even if you're a young married couple. What's going to happen to your kids if you become incompetent or something? All those plans can be laid out. So just keep that in mind. It's something we don't want to talk about, but it's part of life. It happens.
Yeah, definitely. That was some great points pointed out on helping everybody understand that. Mickey, do you have anything to add in before we jump into some questions here?
Just that it's better off, like being alluded to try to plan these things ahead of time and say, well, what if this happens to me, instead of having to wait until it does happen. The power of attorney can be written up in such a way that allows the agent to transact business on behalf of the principal, and then it can be written up in such a way that it either takes effect immediately or it takes effect upon the determination of incapacity. And there are certain guidelines there to determine whether or not the incapacity is there that can be written into that power of attorney. So and it would be behooving to get those documents in place so that you don't have to worry about trying to go to the courts and get the guardianship or conservatorship or both down the road.
Yeah.
All right, that's some great follow-up information. And I think that kind of leads into a great leading into our first question. So this question is, does getting a guardianship mean someone loses all their rights?
Not necessarily. They're at a point where, I mean, they still have rights, but can they make legal decisions for themselves is what you have to look at. And so that's the whole crux of the thing. Their ability to be of sound mind and to make legal decisions on their own behalf, or any kind of decisions on their own behalf, is what you're looking at, because there are what's called lucid moments where a person can be sitting here conversing, seem just fine, and then 20 minutes later they forgot what day it was, they can't remember the President of the United States, or they can't remember their daughter's married name, just different things. You know, there's lucid moments where they know exactly what they're talking about and what they're doing. So you got to look at the whole picture of what's involved with that individual and make decisions based on that, and seek counsel from an attorney. And you know, and that's where the healthcare power of attorney comes in. If you have that ahead of time and you have these questions can be gone over by their treating physician too, because they're going to note, you know, any diagnosis or any problems. But without that healthcare power of attorney allowing them to get that information, they're just essentially dead in the water as far as finding out any information about what mom or dad are going through health-wise. So.
And Mickey, I'm going to throw this next question your way. So if family members disagree about who should serve as a guardian or conservator, what happens?
Basically, in a nutshell there, you could wind up with competing petitions there. So you've got daughter who files a guardianship or conservatorship petition trying to get that over daddy. Son comes in and says, you don't have any business serving that way. I'm going to file my own petition. So you've got a brother and a sister who's arguing over who's going to be the guardian or conservator or both over daddy. And that can create a lot of problems there, because each person is going to have to run into the court and explain why he and she feels I should be the one serving as the guardian or conservator over daddy. Ultimately, there's hard feelings over that potentially. So ultimately, you know, if you have people disagreeing over who should be guardian or conservator, especially if you've got siblings disagreeing over that with regard to who that should be over a parent, you ultimately have to let the court decide that. Which again, that's why I say it's better to go ahead and have those powers of attorney in place. That way then daddy can say, I want my daughter or I want my son to be the agent, and then even name the other one as an alternate potentially. So.
Yeah.
Now, does the court, like we see in some probate cases, when it comes to conservatorships and guardianships, do they do joint powers, or is it just a single person?
The court can. It's not recommended, because then you have to have both agree on everything. And since the parties aren't already in agreement on how to handle mom or dad's affairs, I doubt they're going to be able to be co-conservator and guardian over that parent, because they're always going to disagree about, and then who's going to make the final decision ultimately at that point. So it's not a good idea.
I totally agree with you on that one. Well, guys, that is all the time we have for today. We really appreciate you tuning in every week. We would love to answer more of your questions on air. Please go ahead and send those in to us, legalhelp@jmmtlawfirm.com. And again, we'll be happy to answer them on air. Or if you have any particular legal topics that you want to know more about that we haven't discussed, or you want to just know more about, we would like to hear about that too. We always want to hear the input from our community and how best to serve you guys better.
Yeah, we're thankful for the folks in our community, and you know, we want to be here to help when you have questions or whatever, because there's a lot of conflicting information out there, and so come to somebody who does this on a daily basis and is able to guide you in the proper manner to handle your legal affairs and answer your legal questions. It's too important to leave to chance. So we appreciate you and hope to see you soon.
For sure, and then look out on our social medias for any seminars that you guys put on regarding probate. And we'll see you next week. Have a great weekend.